Sean Combs is accusing the government of deliberately hiding information and wants critical evidence tossed. It is all about those secret text messages from key witnesses and alleged victims. We're going to break it down for you right now. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. In the lead up to Sean Combs' criminal trial, we have some more accusations being leveled against the prosecution, the government, and more importantly, could the prosecution have evidence thrown out that it may really need to secure a conviction against Sean Combs? This is a big deal. There's a lot riding on this. So we're not only dealing with allegations that the prosecution isn't playing fair and that its warrants for evidence were tainted, but it goes to the central theme in this case, the central theme in the defense's case, to be more specific. The defense's argument that what Combs allegedly did wasn't a crime, that everything was consensual, and these people who are going to be testifying against him are fabricating their stories. Let me expand upon this. Let me explain this. So, Sean Combs, as you know, is charged with 3 major federal crimes: racketeering conspiracy, sex trafficking by force, fraud, or coercion, and transportation to engage in prostitution. That he operated a criminal enterprise, that he induced women to engage in commercial sex acts for his own personal benefit, that he transported people across state lines to do all this. You know all this already. Again, very, very brief summary about the case. But I want to read you what the defense alleges in 2 new letters that they filed with the court. And what adds to the mystery of all this is there are parts that are completely redacted. And that's done to protect the names, the identities, the information of prospective witnesses and alleged victims. So let me go to this letter first from March 20th from Sean Combs' defense counsel to the judge, Judge Arun Subramanian. And it reads, quote, "Dear Judge Subramanian, Mr. Combs respectfully submits this letter to supplement his motion to suppress evidence and to alert this court to a recent disclosure by the government. One portion of Mr. Combs' motion focused on," and then it's all redacted, "the government had claimed in its warrant applications that," redacted, "the actual text messages between the two, however," redacted. Now, you're going to be correctly saying, what is he talking about? What am I supposed to be taking away from all that? Everything's redacted, right? Okay. So look, Sean Combs seems to be referring to, and this is based on a prior filing that he references in this letter, when the government's search warrants reportedly relied on information about unnamed Assistant 1. And while we don't know what that information is about, and we don't know who Assistant 1 is, Combs previously made the argument that the warrant applications failed to disclose something. And that's very key because, again, if the warrants are tainted, then evidence may be suppressed. It might not come into trial. So let me lay out the legal standard as presented by Sean Combs' defense team. And that is that under the 4th Amendment, you have a protection against unreasonable searches and seizures from the government, and that a warrant can only be issued if there is a showing of probable cause that a crime has been committed. And according to Sean Combs' defense counsel, the only way a judge can know if true probable cause exists, and to do that analysis, is if the government provides an accurate and complete statement. And if a statement of probable cause in applying for a warrant contains materially false or misleading information, then the warrant's invalid. And any evidence that is obtained as a result of that warrant is defective. That means it's suppressed, meaning that evidence can't come into trial. The jury will not see it. So that's the argument. And by the way, we are talking about a lot of warrants in this case, okay? We're talking about warrants to search Combs' residences, his electronic devices, his person. So this could be key evidence. Now, Combs has previously argued that the applications for these warrants were misleading, particularly about alleged obstruction of justice on Sean Combs' part, and that the government cherry-picked statements to fit a certain narrative or to fit a certain argument that they were trying to make. And when Combs mentions his previous motion to suppress evidence, he argues that the warrants were unconstitutionally overbroad, and B, maybe more importantly, he makes the argument that the government deliberately hid exculpatory evidence, meaning evidence tending to show Combs didn't commit this crime. For instance, Combs argues the government hid evidence in the applications regarding the credibility of witnesses. And as you'll see, he'll make the argument this is something the judge should have seen. Hey everybody, this is a Law and Crime legal alert. Did you know that children are being diagnosed with serious conditions like type 2 diabetes and non-alcoholic fatty liver disease, and the research is potentially linking ultra-processed foods to this? Yeah, well, Morgan & Morgan is stepping in to fight to hold these food companies accountable. With decades of experience fighting large corporations, they are ready to stand up for the families who deserve justice. So if your child under 21 has been diagnosed with type 2 diabetes or fatty liver disease, then visit www.forthepeople.com/food or scan the QR code on screen to learn more. So writing in a previous filing, it says, quote, "The government relied on information from sex worker 1, but sex worker 1, and again, we don't know who this person is, but sex worker 1 has also given the government exculpatory information, none of which was included in the warrant applications. These statements from a key participant in the FOs, the freak-offs, undermine the allegations." Now, the information is all blacked out, it's redacted, so we don't know what was said or presented, but we get the main idea of their argument here. And Combs had also argued that the government didn't disclose in its warrant applications exculpatory information regarding victim 1's consent and financial motive. That is their interpretation of it. Now, we believe victim 1 to be Cassandra Cassie Ventura, who initially filed her lawsuit against Sean Combs back in November of 2023 that sparked the plethora of lawsuits that Sean Combs now faces. And of course, this all led to his criminal charges. And we believe that she's victim 1, and we believe she will be a key witness at this upcoming criminal trial. But they write, quote, "The core allegation in the warrant applications, and indeed the government's entire case, is that Combs forced victim 1 to participate in FOs, freak-offs. In its March warrant applications to search the residences, it stated, redacted, this statement was based on the investigator's interview with victim 1, which took place 5 years after the events. But the government unaccountably failed to inform the magistrate, meaning the judge, redacted, both of which severely undermined its account." So again, trying to go to this idea that there's more to victim 1's story. Combs further argued they are important evidence. They show the context of the relationship, and they also, redacted, they are, quote, "the kind of thing that any magistrate judge would wish to know when reviewing a warrant application in a sex trafficking case. Yet the warrant applications contain not even a hint of them. They didn't even inform the magistrate judge that this evidence existed." And as Combs explained, while investigators need not present a magistrate with every bit of evidence they have discovered, they must nonetheless include a reasonably even-handed account, and they cannot omit critical exculpatory facts that might undermine a finding of probable cause. Okay, so I say all this to go back now to the March 20th letter filed by Sean Combs' defense counsel, which we're talking about. So in this letter, Combs' defense continues and criticizes the prosecution's explanation for why it apparently claimed one thing in the warrant applications, but then the sealed, redacted text messages say another. Quote, "In its opposition to the motion to suppress, the government claimed ignorance. It argued that the government did not have this full thread until months after the challenge warrants were issued, which they claimed was dispositive to the argument." Actually, in the government's filing, interestingly, they argue that if all of this was included, it would actually help their case. It would hurt Sean Combs. They write, "The inclusion of the full set of messages would have only strengthened the obstruction case against the defendant and his co-conspirators, and therefore cannot be material to the finding of probable cause." And they make other arguments, too, that it's allowed under the law to omit certain details or information. Maybe we'll get to that in a little bit. But anyway, going back to Combs' current letter, his defense counsel writes, "On March 17th, 2025, however, the government produced discovery from redacted, which included multiple screenshots, including fuller context of the messages. The government sent the defense correspondence in which it revealed that it had these screenshots back in February 2024, which, by the way, is before the raids on Combs' houses in LA and Miami, and months before his arrest and indictment." Combs continues, "The government explained, quote, "We recently realized that the screenshots had not been part of one of our prior Rule 16 productions to you and promptly produced it to you. We apologize for this oversight. Note that the content in the screenshots was otherwise provided to you in warrant affidavits and redacted phone." And Combs argues, the fact that the government received screenshots demonstrates that the government was in contact with redacted, this unnamed person, and could have obtained whatever additional context was required. And given that investigators had requested and received these specific screenshots from redacted, it is utterly implausible that the warrant affiant himself, the lead investigator on the case, had not seen them. the full context should have been included. Instead, the government plucked a few bits out of context and included those in its warrant applications. In other words, you had the full picture, and you should have presented it to the judge so the judge could then properly decide if there was sufficient probable cause for a warrant. And again, this is all in further support of Sean Combs' motion to suppress, which would be a big thing for Sean Combs' case leading up to trial, because although we don't know exactly what was found pursuant to these search warrants, I mean, it seems like potentially digital evidence like text messages, videos, hey, maybe even the 1,000 bottles of baby oil, maybe the guns that were found as well or allegedly found. So to potentially have all of that tossed from the trial would be a major, major win for the defense. But that is not the only letter the defense filed. No, now let's talk about the letter that they filed on March 26th. Quote, "Dear Judge Subramanian, Mr. Combs respectfully submits this additional letter to supplement his motion to suppress evidence and to alert this court to additional recent disclosures by the government. Mr. Combs apologizes for the serial filings, but these additional recent disclosures contradict the government's assertions in its opposition to his motion to suppress. Mr. Combs' motion noted that several of the alleged victims and other witnesses had pursued civil claims against him and thus had motives to exaggerate or fabricate. Although the government has an obligation to reveal information going to the credibility of informants, the government's warrant applications redacted." So we don't know what Combs is claiming the warrant application was missing, but it is interesting hearing this argument because we have always wondered, and we still wonder, what is the overlap between all of the civil cases that Sean Combs is facing and the criminal case? Who's going to testify as either an alleged victim or witness? Or at the very least, was there something from someone connected to a civil case? Some piece of information that the government used in these applications to gather evidence in the criminal case? And it's interesting because Sean Combs has always been adamant that he's innocent of all of these allegations, both in the criminal and civil context. But when it comes to the civil context, he's also made the argument that these people are coming out of the woodwork for a payday, that they're all ganging up against him, that they're all jumping on the bandwagon. Now, going back to the letter, it says, quote, "In its opposition to the motion to suppress, the government again claimed ignorance. It argued that Combs had not made any showing that the affiant was aware of many of the alleged omitted financial motives. More specifically, the government asserted it was not aware of redacted. The government similarly stated that they were not aware of redacted." Again, don't know who this person or persons are. "As such, any omission of this information clearly cannot satisfy the intent prong of the analysis." So intent meaning that in order to get evidence suppressed, you have to show that the material information not included in the search warrant applications was omitted because of a subjective intent to mislead the court or even reckless disregard for the truth. But Combs continues, "Once again, recently disclosed evidence contradicts these assertions. In early March 2024, prior to the warrants on Mr. Combs' person and homes, redacted. Prior to seeking the challenge warrants, the government was thus clearly aware of redacted. The government's representation to the contrary in its opposition is flatly and demonstrably false." It's a big thing to basically accuse the federal authorities of being dishonest with the court. And then Combs addresses something called 3500 material, basically statements from government witnesses who are going to be called to testify at a trial. The letter reads, "The government also recently disclosed additional 3500 material demonstrating that government agents, including the warrant affiant himself, were in regular communication with both redacted and her attorney, and that it had a copy of redacted. Finally, recent evidence also demonstrates that the government knew victim 4 was redacted." Now, victim 4, again, we don't know who this person is, but this is somebody that Combs' defense team referenced in its prior filing in support of suppressing evidence, writing, "The warrant applications included allegations that victim 4 redacted. The government made no effort to corroborate victim 4's claims. If it had conducted a reasonably competent investigation, it would have obtained evidence contradicting her account." So again, government, you didn't include what you needed to about victim 4. Now, finally, Combs wraps up this March 26 letter, writing, "In adjudicating Mr. Combs' motion to suppress, this court must determine whether the warrant applications were intentionally and materially misleading. The Franks inquiry is not limited to the affiant's knowledge alone and instead is shaped by what the investigative team knew under the collective knowledge doctrine. The warrant applications were obviously reviewed and approved, if not drafted, by the prosecutors, and anything they were aware of is attributed to the government for purposes of Franks. It is troubling enough that the government's opposition to Mr. Combs' motion was itself intentionally and materially misleading. Now, by the way, a Franks hearing is about a court determining whether and to what extent a member of law enforcement provided false or misleading information that was necessary or material in applying for a search warrant, and whether the search warrant is invalid, and again, whether evidence will be suppressed. So basically, it's everything that we've talked about so far. Also, by the way, the collective knowledge doctrine, that's when you have investigators working together as a team, and the knowledge of one officer can be imputed to another as a whole, so they all have a collective knowledge about something. And by the way, the government has previously opposed a Franks hearing in this case. They wrote in a previous filing, quote, "The Franks standard is a high one. To obtain a Franks hearing, a defendant must make a substantial preliminary showing that a deliberate falsehood or statement made with reckless disregard for the truth was included in the warrant affidavit, and the statement was necessary to the judge's finding of probable cause. This burden is a heavy one, and such hearings are rare. The law recognizes that while an officer may not disregard plainly exculpatory evidence, an affiant is not required to include all potentially exculpatory information in seeking the search warrant. The defendant fails to demonstrate that there were intentional misstatements or omissions in the affidavits, and that those misstatements or omissions were material. To the contrary, the defendant relies on rank, unsupported assumptions about the government's access to and knowledge of facts at particular points in time during its long-term investigation of the defendant's crimes. Moreover, and fatal to his motion, the defendant makes no attempt to show that the affiant acted with a subjective intent to mislead the issuing magistrate judges or with reckless disregard for the truth." So, no ruling yet from Judge Arun Subramanian at the time of this recording on this very specific issue, with a lot riding on it, but of course, we will keep an eye on what happens next. That's all we have for you right now here on Sidebar. Everybody, thank you so much for joining us, and as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. I'm Jesse Weber. I'll speak to you next time.